Right, welcome to the third session on the genetic revolution. Those of you who are here for the first two sessions have already heard some interesting talks and some discussions. But before I start, I think we should acknowledge again the indigenous people who lived on this land for many, many years before white people came to Australia. And I don't regard that as just a piece of knee-jerk reaction. I regard that as a chance to reflect on our commitment to Aboriginal rights and Aboriginal equality. When I used to lecture on ethics, I always made the point that there are some issues on which almost everyone agrees, and these are nice, simple issues in ethics. But the interesting issues are the ones that always pose a problem because you can see very, very important good uses for them and perhaps some problems as well. And a new knowledge can almost always be used in many ways. Let's take DNA sequencing. One of the articles I looked at in the past week is a proof of principle finding on sequence-based cancer gene profiling approach. And this is already happening. People who come in with breast cancer, colorectal cancer, several other common cancers. We're not dealing here with things that only occur once in a million cases. Common cancers will have those cancers tested. The genomes are tested at the moment. It's usually done looking at proteins, but it's going to be done at the DNA level. I'll tell you why in a minute. So we actually have a situation where if, God forbid, any of you develop cancer or have cancer at the moment, and the kind of therapy that is required depends upon an analysis of the mutations that cause that cancer, you're going to get a DNA test. And that's important. So the thing that is driving, I think it's very important to make the point, because sometimes people say, oh God, let's not do this research. We can't not do this research. And the reason we can't not do this research is because some of the fundamental advances that are involved are going to have a major impact on public health. If anyone today develops hemochromatosis without knowledge, that's a failure of the system. Because there's a test that costs about $10 that can tell you you're going to develop it, and that test should be on offer to everyone in Australia because it's a preventable disease. So we have drivers that are perfectly good drivers. Not only that, if you like, ethical drivers. Ethical drivers because they're going to make a difference in an ethical way to the community. At the same time, we have all of the lovely stuff that comes out. Matt Ridley talked about some of it. We have the gay gene and the how to run faster gene and the like to sleep around blame your genes gene, which I think is, we could call it, if you're watching the telly, the Kennedy gene. Or we have my favorite is happiness gene found in US teens. I don't know what US teens they're looking at. They're not the same ones I am. Anyway, there's a happiness gene. There you go. So that's all very well. But the truth, of course, is that there are problems that come up in between. And the Alzheimer's test, which I mentioned before, is one of them. Here's a gene test, which roughly 15% of people are positive for, and those 15% of people have a roughly 20% risk of developing Alzheimer's disease in the ages between roughly 65 and 80. And you might say, oh, God, I don't know, that's a problem. I'd worry if I tested positive for that gene, and I still have a 4 in 5 chance of not developing Alzheimer's disease. But what about the 85% of people who test negative? Their risk goes down to about 1 in 200. They can go and worry about something else. So basically, you have a situation where doing a test like that really is important, and you got to get the balance right. You've got to get the balance. Ask yourself, do you want to know this? However, in Australia, we have something else happening. Here we have, any of you read, most of you probably read The Age, IVF breakthrough. Advanced embryo selection gives you the best chance to have a baby. It's Melbourne IVF. A very interesting article. I'm sure you all know that between 3 and 5% of babies in Australia are born using IVF. And the vast majority of these are wanted children, and the vast majority of people think this is a good idea. Now, if you're at risk of having a child with cystic fibrosis or thalassemia or muscular dystrophy, you can go down the IVF route, get pre-implantation genetic diagnosis, and they can take a single cell from that embryo when it's 8 cells big, take that cell and do a DNA test on it. And they can tell you that, and they usually make 8 or 10 embryos, and they do that for very good medical reasons. They don't do that because they want to give me embryos to experiment on or anything like that. I don't actually do any experiments on embryos, but that's not the reason. The reason has nothing to do with experimentation. The reason is very, very good medical reasons for making 15 roughly at a time. And they'll say, well, 4 of them would be affected, so we'll put those to one side, and 11 are okay. But they don't say the next thing. And by the way, since we're doing a DNA test, we can do a DNA test not just for the cystic fibrosis gene, but for 96,000 genes, all at the same time, using a DNA chip. So we can actually tell you whether of those 11 embryos, which ones will give boy children, which ones will give girl children, which ones will be fast runners and which ones will be slow runners, and all the rest of that stuff. And one of the principles, oh yeah, it's great, single cell expression profiles, here it is. And you don't even need to go in and do it by IVF really anymore, because researchers have shown you can characterize the fetal genome patterns in DNA from maternal blood. So you take a maternal blood sample at 8 or 9 weeks and do the fetal DNA on that. And you might think, oh, this is going to be bloody expensive. This is for rich people. US $99 sale price, marked down from the regular price of $279. So 99 bucks in Australia is today. Not bad. Anyone 8 weeks pregnant? Want to try it, you know? The basic principle ethically is that a couple of principles, my colleagues here can tell me off if they don't agree, but first, it's not a good thing if doctors hold information which they refuse to give people who are patients, people who are seeing them. By and large, if you do a test and you get some data, you should share that data with the people who are most interested in it. Second principle, people have a right to choose. Remember that roughly 97–98% of terminations of pregnancy are done for social reasons, economic reasons, some reason that has nothing to do with medicine. And so it's really not for us to say, for me to say, well, that's not a serious enough issue for you. I mean, we don't say that to people. Most of us believe people have a right to choose whether or not to have children. Final point on this is the point I made before. Knowledge empowers. Knowledge isn't always easy to have, but knowledge empowers people. Knowledge gives people choices. Knowledge gives people autonomy. Knowledge gives people the right to make the... I've never believed that, there's talk, the right not to know. I always regarded the right not to know as a little bit like the right to think the earth is flat. Do you have a right to think the earth is flat? Sure you do, but it's not. You have a right not to know, you have a right not to know, but it's a disempowering right, it's a false right. We've got to solve the problems in other ways. So I suppose saying knowledge empowers, the key word there is usually empowers, but there's another key word, and that's knowledge. And one of the things which I hope people go out of here with the concept of is we have got to improve our science teaching, our genetics teaching, our knowledge for the community as a whole, which is one reason why I think this is a really important event. So we're now going to have 3 talks, great talks here today, and the first is from Professor Ian Anderson. When I first met Ian, he was Professor of Indigenous Health, which is still, of course, a major interest of his, but he is now Director of Barak, the Melbourne Institute for Indigenous Development. And as I said at the beginning, I think this commitment is an important commitment for every Australian, and so I'm very much looking forward to hearing what Ian has to say. Ian.
Thank you. I feel a bit like the bunny in the headlights with these bright shining lights. Now I'm just going to wait for my take on this. I'm neither a geneticist or neither am I an ethicist, but I've been involved in Aboriginal health for some 30 odd years and increasingly been working in the space around knowledge development and how do we broker ethical relationships around research practice. On the broad understanding that research contributes considerably to providing us with the know-how to close the Indigenous health gap, amongst other things. Now, I want to talk a little bit about three very simple ideas. One is some of the legacy of a discussion around research in the genetic space, something about some of the work that we've been doing in Indigenous communities around building ethical frameworks for research, and then bring it together and talk about some of the work that we've been particularly doing here at the University of Melbourne with my colleague Emma Cavall, and also through the Lowitja Institute, which is Australia's national Aboriginal and Torres Strait Islander Health Research Institute, to tackle what is a really challenging question for us. How do we build an ethical framework around genetics research in Indigenous Australia, and how do we build constructive and ethical partnerships around research in this area? Aboriginal Indigenous Australia, as you'd be aware, is an incredibly complex and culturally diverse community, but with many common experiences over the last 200 years, and not very necessary good constructive experiences in the field of research. We're here, down here in Melbourne, in the land of the Wurundjeri Kulin. It's too complex. My mother's family actually are Aboriginal, and they come from a place on an island that was called Trawunna, and around the Bay of Fires and Pummarana clan groups, and Pummarana tribal group with Pummarana and Chawalaway clan groups. We were also connected through the Bass Straits to most Aboriginal communities here in Southeast Australia. And I want to make that point because some of the early thinking around Indigenous Tasmanians and Indigenous Australians more generally was very framed to this construct we now call race. This is particularly evident, this is a picture of a work by Anna Johnson and Mitchell Rolls, who examined the writings of Charles Augustus Robinson, who recorded some of the more traumatic years on the island of Tasmania and the history of Aboriginal people there. And one of his historians that I was asked to read and reflect on was a guy called Norman Plumley. In this particular paper, I came to a more reconciled view of Norman Plumley, but I very much remember reading his writings as a small child, and because I was quite interested to learn more about my family's Aboriginal history. And he writes about Aboriginal people from the Bass Strait Islands, where my family come from, in the terms of being half-castes or hybrids, and this is a direct quote from him. It must be emphasised that hybrids are the products of two racial forms, and their characters are a mixture of those two through genetic dominance may direct the expression of one rather than the other. Structurally, physiologically and psychologically, hybrids are some mixture of their parents. In social terms, they belong to neither race and are shunned by both, and lacking a racial background, they have no history. Now, I actually remember as a teenager reading that last time, they have no history, and burst into tears. You know, perhaps at a kind of a more emotional period of your life, but looking for history when we were told because of this racial definition, we were outside of history. In actual fact, the history of Indigenous Australia had a very significant impact to the racialisation of identity. It had a real impact on how people were represented. It had impact on rights and lived opportunities. If you were defined as a half-caste or quarter-caste, it determined your access to social welfare, your right to vote, and in some jurisdictions, your right to employment and your right to move. Now, in very real, now that was a way in which race framed the way in which people were taught and written and thought about. Now, we have moved a long way from the notions of race, and more generally, there's been a very general shift away from race as a scientific concept. But it does hover in the background of most conversations about genetics, and hovers in the kind of the elephant in the room, the unstated threat. For indigenous peoples across the world, there are genetics throws up fears of biopiracy, issues around the collection and use or misuse of tissue samples, the potential harm caused by the representation of genetics research or the misrepresentation of genetics research in the press. And we'll give some of the examples of that. But also, and it's also quite evident around some of the very contested and hotly debated projects such as the Human Genome Diversity Project in the early 1990s. Nevertheless, it's, for a number of reasons, a number of us feel that it's very important to move beyond this history and to find ways to have constructive dialogue. And we believe, and there's a lot of argument now, that there are some really fundamentally important ways in which we can move forward to building relationships in contested areas of research. One of those comes through, and this is using a framework by the Maori writer Mason Dury and some work here in Australia. They talk about three forms of engagement. One is mutual recognition, the recognition by researchers that there is a need to engage not just with individuals but with Aboriginal community structures in the process of research. Also, the second is that an ethical encounter requires mutual comprehension, the ability to engage socially, to respect different cultural values and to engage in a way that recognises and respects indigenous values, or what Mason Dury calls the ethics of engagement. And both of these, through mutual recognition and mutual comprehension, it is argued that we can move towards a more reconciled approach to research, away from a hotly contested field of research, but one which is built on engagement and shared understanding. So I now want to make a couple of comments around some of the history in the ethics of research, which is much more general history around Aboriginal health research, but has particular pertinence in the field of genetics and the genetics revolution. The approach to looking at engagement around the ethics of research emerged in the context of very hotly contested relationships in the late 1960s and the early 1970s, very much framed by the Aboriginal civil rights movement and the Aboriginal political rights movement that emerged in the 1970s. There were two seminal events in this period of time. One was in Alice Springs in 1986 when the National Health and Medical Research Council convened one of its first conferences, Research Priorities to Improve Aboriginal Health, in which over 200 people were registered and they had 100 speakers. It was very much framed around developing a biomedical research agenda. The conference made the local press, and was some local controversy in the Northern Territory. It was claimed that it was taken over by Aboriginal activists who seized control of the agenda. And as one of the outcomes of this is, none of my colleagues were involved in both sides of this particular event, talk about moving away from a conference agenda around setting research priorities to one actually talking about the ethics of research. And subsequent to that, there was a very important workshop in New South Wales in August the following year, which actually started to formulate some guidelines for how we might build an ethical approach to research, move past the sense of being exploited and to one which defines some of the benchmarks for what is ethical practice in Indigenous Australia. Some colleagues did a small oral history of this particular approach, and it's very interesting if you reflect on both sides of this encounter. I think everyone shared a sense that this was a very fractious and kind of contested and argued and fraught process, but nevertheless, from the words of Shane Houston, who was then the National Coordinator for the National Aboriginal Islander Health Organisation, and is now actually one of the DVCs at the University of Sydney for Indigenous Strategies, talked about this being one of the first examples where community actually was involved. Aboriginal community was involved in taking control of an issue and saying this is setting the framework, setting the parameters for the relationship. On the other side, a good colleague, Professor Ross Calusi, who was a professor in the NHMRC, and I won't read out his full quote is that he actually made a point that this, even though it was a very traumatic experience, it made a very profound and significant impact on the thinking within the National Health and Medical Research Council, and thinking that had much broader implications in particularly other areas such as HIV/AIDS, and gave particularly an establishment to an ethical framework and process around the development of research proposals. More recently, there's been a further innovation in terms of thinking around guidelines for Aboriginal and Torres Strait Islander health, and I won't read this through in detail, but this is an illustration of the development of a values-based framework. In this framework, rather than setting benchmark or rules for research practice, you shall do this, you shall not do this, and this is how you keep data, this process really started to talk about what are the sort of values that we need to talk about in a shared research space between the researcher and Aboriginal and Torres Strait Islander communities. And saying that in order to get to mutual comprehension, we need to have be able to have a conversation about our shared values and the shared assumptions which influence the things that we think are important and the things that we worry for. So, for example, in the link between the section on reciprocity, there are a couple of statements that illustrate how you might think through reciprocity in research processes. For example, that each research protocol must be designed to ensure that the respect for and the dignity and well-being of the participants takes precedence over the expected benefits to knowledge. And I won't go through this in more detail, but this has been a very significant development, and one which leans us further down that track of thinking about how we talk about the values and the values that matter to us when we're engaging in research. So the final comments I want to really make is about how do we think about this application in genetics. And we think it's very important to do this because there are a number of potential benefits for Aboriginal Australia in this particular research field. There's enhancing our understanding of what causes the disease, to get a better sense of the relationship between genetics and environmental risk, to be able to predict disease risk, and particularly to assist us in developing novel diagnostics, drug targets and broader interventions. But in order to do this, we need to tackle what is a very particularly fraught area of research. The Lower Institute is an institute the university is a strong partner with, named after a woman of a considerable gravitas, Lower O'Donoghue. One of the mandates of the Lower Institute is to tackle those areas that are difficult. It's an indigenous run organisation, and we think that that's partly critical to give us some of the mandate to take us into areas which are previously not on the page. So in July last year, we held a roundtable on Indigenous genetics research. It was attended by 24 Indigenous and non-Indigenous attendees, including experts in genetics, Indigenous health research, Indigenous research ethics, genetics ethics, and genetic literacy. And it was a safe conversation, it was a safe space, but we wanted to, and this was a group of colleagues, Aboriginal and non-Aboriginal colleagues, who shared a common problem of how do we actually work in this very challenging area. Within that context, we had some really fascinating discussions, and I'm not a scientist in the field of genetics, so I'm not going to take you in detail through the meaning of this, but really reflect on a part of that conversation, and I'm going to actually read a part of Emma Cavell's writing up of this. One of the issues that was raised by a researcher at the roundtable related to population structure. So when a genetic researcher compares two different groups, such as one group who have a particular disease and another group that does not, it's important to find from a scientific perspective to check that the two groups are comparable in terms of their ancestry. And genetics will look. For this reason, geneticists argue that they must control for different ancestries for the two groups. Otherwise, and the way to do this is through looking at population structure. So when you compare two groups and the frequencies of apparently gene-related diseases, you need to know whether they actually share a common ancestry or whether they're completely unrelated. One of the ways in which this is done is using principal components analysis. Now, the method produces a schematic diagram comparing the genetic ancestry of different groups. Drawing on his work from Pakistan, the researcher showed, for example, that how principal component analysis found that Hindu and Muslim people from one village she worked with were actually quite genetically distinct. If she had found a gene that was present in the Muslim population, not in the Hindu population, she might have mistakenly thought it was a disease gene when in fact it reflected a different population history. What was so, and in this particular group, this is one analysis produced by this researcher. The graph is shown as an upside down V with Asian populations on the bottom left hand side, African populations in the right hand side and Caucasian populations at the top, with South Asian and Middle Eastern populations in between. Now the researcher was then able to show where a particular Aboriginal group fitted into this schemata. What was really interesting though was not in the it was both in the discussion about the science, but also into how some of my Indigenous colleagues responded to the representation of the science. One man talked particularly about the need to build capacity within our Indigenous communities to engage in this sort of conversation, and then asked the question, why is it that Caucasians are at the top of the diagram? Now, the researchers, there is no particular reason why the diagram is represented that way. It could be on the side, it could be down the other way. It represents relationships. And the researcher is a fantastic researcher and has developed very good relationships with the Indigenous Australians, but had not thought through the possibility of the other form of interpretation that Aboriginal people might bring to his analysis. So this, I think, raises the very challenging question about how you build the shared comprehension in order to have an ethical conversation. Mutual engagement raises questions about who to engage with and how in terms of Aboriginal communities, but mutual comprehension involves a very complicated dialogue on the potential and often deferred benefits of genetics research and the potential and perhaps more immediate risks around representation. But it's a really important part of the dialogue in order to have a shared understanding and a shared engagement. So for us, this was suggesting that there is an awful lot of important work that we need to do. This work not just about guidelines and research and what is good ethical research, but work on building the tools to build a literacy that in communities who are participating in this sort of work can actually have an understanding, a shared understanding with their researchers that enables them to make ethical decisions. It mightn't take them all the way into the science, but it also enables them to communicate some of their fears, some of their concerns, and some of the issues so that both the researcher and the community can come to a shared view of what the potential benefits are and a shared view of what the risks are, and then weigh up a decision about whether and how to proceed. The final bit of this conversation, which I think was most interesting in terms of the work that we've done, is that underpinning in all this was a notion of trust. How do you build trust in these research relationships? Trust despite disparate histories, trust despite different sets of values, in order to come to a constructive and ethical approach to what is a really challenging but really exciting area of research. So thank you.
Thanks very much, Ian. As in the other sessions, we'll hold questions and discussion, but that doesn't mean we'll forget questions and discussion, because I think Ian made a lot of very interesting and important points there. Our next speaker, we really do have three speakers who have so much talent. I could spend the whole time just describing them. Lo-Anne Skene is familiar to many people here, but she is, of course, Professor of Law here at the University of Melbourne. She's played many other senior roles for a fairly long period of time, was Chairman of Academic Council. But from the point of view of this particular discussion, she was a member of the Lockhart Committee on Embryo Research 4 years ago now, 5 years ago, and was the only person who was on the Lockhart Committee to be reappointed to the new committee, the HERE Committee, which has not yet reported, and I'm sure she can't tell us about that yet, but nonetheless we're waiting expectantly for what that will be. Lo-Anne Skene.
Thank you, Bob, and hello, everyone. Now, what I'm going to do in this short presentation is to tell you about the development of legislation in Australia, what legislation we've had, how it's seen to reflect community values, and then what changes there have been both in the legislation and the science since this technology started to develop. So in Australia, in 2002, 2 acts were passed by the Federal Parliament, and we can call these the Prohibition Act, which prohibited a wide range of practices that were seen to be of community concern, and the Research Act. And the Research Act enabled particular types of research to be done under licence, provided that there was ethical monitoring of the research, there was a licence granted for it, and later a report to Parliament. And since those acts were passed, each of the states has passed mirror legislation, which is still, despite later amendments, almost the same throughout Australia. Sorry. So under this national legislation, it is a crime to do certain acts that people are seen to be concerned about. So to use the technology to breed identical people or human-animal hybrids is totally prohibited, and the implantation of any research embryo of any kind is prohibited, and you're also not allowed to develop an embryo that's been developed for research for more than 14 days, and it's an offence to sell human sperm, eggs and embryos. Sorry, I don't seem to have the knack with this. So this means that reproductive cloning is banned. There'll be no duplicate people, the sort of thing that people are really concerned about. And we won't have human animals. And eggs won't be sold. So each of these acts are the sort of things that people expressed concern about in the community consultation before the 2002 acts were passed. However, embryo research was permitted from 2002 under licence with embryos that were donated from IVF programs. So women who are on an IVF program have a number of embryos formed, and those embryos are selected in the way that Bob described at the beginning of this session to see the ones that are not fit for implantation. Some, one or more, may be implanted into the woman in a later menstrual cycle in order to try and have a baby, and then the others are stored so that if they're not successful the first time, the couple can try again later. So those embryos are frozen. They're not allowed to be frozen for more than 5 years. And at the end of that time, a decision has to be made about what to be done with them. And there are 3 choices. They can donate the embryos to another couple in the IVF program, they can donate them for research, or they must be destroyed. So these embryos are available for research, and many couples would rather donate the embryos for research than have them destroyed. One of the points I want to make about this type of embryo research is that many people think this is to get stem cells for research. But in fact, over half of the licences granted for this type of research have been to assist people who have infertility problems. And there is a large number of these people who want to have a baby and can't. It's also to investigate early birth defects. So many people who have a baby with something wrong ask these questions. And one way to investigate and try and help people avoid a birth defect in future, if it's a genetic type, is to look at the early embryo in its first development and see if you can find anything that's going wrong to understand the development of the embryo. And also, of course, those embryos are used to get embryonic stem cells for research. So what has happened since 2002? The research is of different kinds. So I've mentioned some of the purposes of the research, but one of the other important things with the stem cells, once you get them, is to develop what they call a disease in a dish. So if you find a patient who has a particular genetic mutation and you're able to get stem cells from that person, all of the cells in your dish have got the same mutation. So that's very useful for basic research and to develop new drugs and to just understand what's happening in the process of development of those cells. Some of them are differentiated into different kinds of cells, which it's hoped will one day be used to treat diseased tissue. Now, in 2005, the Lockhart Committee was formed to review the 2002 legislation. And it conducted a very extensive inquiry to try and find out more from scientists and other stakeholders, and also to find out what the community thinks about stem cell research. Here's a copy of its report. There were in fact 2 reports, one on each act, and they were very substantial. They've received various awards and they've been praised in other countries for the recommendations that they made. So this Lockhart review was very well funded and very extensive, and it had a lot of administrative and other backup. The major change that it recommended was that somatic cell nuclear transfer should be allowed to obtain matched tissue, matched stem cells, subject to licensing and reporting. Now, this obviously extended the type of embryo research that could be done, because in 2002, you could only use embryos that were surplus from IVF programs. Once this amendment was adopted in legislation in all states and in the federal parliament and all states except for Western Australia, it was possible to create a type of embryo specifically for research. And you will know this process perhaps as the Dolly project. So what it would involve is similar to the sheep Dolly who was cloned. So what it involved would be to take a skin cell from me, to remove its nucleus, and to put that nucleus into a donated egg that has had its nucleus removed, and stimulate it to produce an embryo, a type of embryo, and then if the stem cells were derived from that embryo, they would be almost entirely the same as my DNA. So the advantage of this would be that you, instead of just getting random stem cells, as you do with embryos that are donated from IVF, it would be possible to get stem cells that have the exact characteristics of the person whose body cell is used for this process. As I said, the Lockhart recommendations were implemented in the federal parliament and in all of the states except for Western Australia. This is a picture of the Victorian Parliament, and you can see Ted Baillieu, who was not then Premier, sitting in the middle of the government members, and this is to indicate that it was a conscience vote. It was the second longest debate in the federal parliament when the federal amendments were going through, and as in this slide, that was a conscience vote as well. Now, since then, I want to look at what's happened in science, because obviously when the legislation was reviewed again earlier this year by the Hearing Committee, it was very important to see what had happened in science since the last review. I love this picture because I think this picture shows you the potential of stem cell research. Now, this is adult stem cells. Adult stem cells are all the ones that aren't embryonic stem cells. This patient had failing vision in one eye, and it was possible to take some stem cells from the other side, the patient's other eye, to develop those on, in vitro, to put those new stem cells onto a contact lens, put them in the patient's eye, left it there for 3 weeks, and after that, the patient was able to have much better vision. New body parts are starting to be manufactured. So in the UK, this slide shows you a patient's trachea being formed with the patient's own stem cells into a new body that can be put into the patient to replace the damaged trachea, the windpipe. Not far from here at the Bernard O'Brien Institute, they're talking about different types of regeneration surgery to use stem cells to regenerate tissue, like tissue that's been removed after a mastectomy. There have also been developments in embryo research, and of course this is what's most significant and what the real issue is about this type of research. So in Australia, an Australian research team became the first to grow human embryonic stem cells used into a model for Huntington disease. So that means you've got a whole disease in a dish, Huntington disease, that you can use for research. In the US, a retina has been created from human embryonic stem cells, so this could have great potential in the treatment of blindness. The Geron trial has just started and patients are being enlisted. They now have 2 patients. These are patients who have acute spinal injuries and are paralysed. This is a phase 1 trial, which means that the purpose of the trial is to see whether it's safe to put stem cells like this, embryonic stem cells, into a human patient. The application to the Food and Drug Administration in the United States had 85,000 pages. So they've done everything that they can before they start the trial. One patient anecdotally has said that he thinks, although it's in the very early stages, that he can feel some sensation in his legs. So this would be a very dramatic event if this happens. We've heard earlier in the day about the type of DNA that is passed from the mother without being in the nucleus. So if you imagine a poached egg, and the yolk is the nucleus and the white is the cytoplasm, these mitochondria are in the cytoplasm of the egg. And by a couple forming their own embryo and taking the nucleus of that egg and putting it into a donated egg, like somatic cell nuclear transfer, you would have healthy cytoplasm with the DNA from that couple in the new embryo. Some laws have been changed in other countries to assist embryo research. In New York State, you can now use federal funds to pay for eggs, not allowed in Australia. In the UK, you can use animal eggs to incubate an embryo. But pluripotent stem cells have now been derived, and people say, why do we need embryos for research? This is iPS cells that were developed in Japanese research. And people also say, what have you achieved with your SCNT? So far, you've got no stem cells. So looking at all of those developments to date, these were the issues that the Hearing Committee had to consider in its review of the legislation. It recently reported to Parliament, and its report will be tabled in due course in the Federal Parliament, and it will then be publicised. So it will be reporting, or it has reported, on the sorts of things I've described to you, the changes in the legislation here and in other places, what's been achieved in science to date and what is hoped for the future, what limitations there have been in what has been achieved to date, and particularly in the light of no stem cells having been derived from SCNT embryos, whether scientists still need to do embryonic stem cell research. So I won't give you the terms of reference, I'll just sit down. Thank you.
Thanks, though, Anne. Sorry to rush people a bit, but obviously we want to have maximum time for discussion at the end. Well, our third speaker is David Weiss, and from the point of view of this discussion, he isn't any longer chair of the, he's professor at the Centre for Legal Governance at Macquarie. But we really know him for the two reports that were issued over the past 10 years, one of which in particular, the one on the ethical issues involved in genetics, discrimination, and so on, I would say is an absolute landmark, possibly the best report that's come out anywhere in the world on this issue, and one which I think everyone has and reads. So, David, welcome.
Well, thank you very much, and thank you very much, Patrick McCackey and the organisers for inviting me to what is a superb conference. It's being described, I see, as Melbourne University's gift to the city, but I think given it's being streamed and friends of mine all over the world, friends and family all over the world are following it, I think the gift has reached much wider, and again, I congratulate you for that. I should also start with a bit of disclosure, being a lawyer and an ethicist. I'm not a doctor, and I'm not a PhD in science. However, I am Jewish, and I have a genetic predisposition to advise other people about their health. So I feel quite comfortable in taking this on. A second to get me there. How to do it the good old-fashioned manual way. Okay, I have been a lawyer for a long time, and the last time I intersected with science was when I did a subject literally called Biology 101 in my first year at university. I had to do biology and physics 101. I enjoyed them, but it never occurred to me to continue on in science. In August 2000, a postgraduate law student at the University of Melbourne teamed up with a genetic counsellor at the University of Sydney and did a survey. It was an informal, fairly crude, they would admit, survey of genetic support groups. And it was a photocopied sheet that went around to people, not a scientific collection, but went around and said, have you ever been the victim of discrimination based on your genetic status? And about 100 people reported positively. They said mostly in the area of insurance, but also employment, access to government services, and a few other areas. And that was reported quite soberly on the front page of the Age and the Sydney Morning Herald the next day as Brave New World hits Australia. Genetic discrimination is here. What are we going to do about it? I got a call that night at home from the Attorney General who said, did you see that story on the front page of the newspapers? Do you want to do something in that area? I said, yeah, it sounds fascinating. I would love to do that. I thought I'd have a bit of time to learn what a gene is or a chromosome and those sorts of things that are now an important part of my life. Well, actually, I always have been, but I didn't realize that at the time. And I said, yeah, sure. And I was in the shower the next morning, and there was the Attorney General on AM, on ABC radio, announcing the inquiry. So we had to hit the treadmill very quickly to learn this. And shortly thereafter, a joint inquiry was formalised that involved the Australian Law Reform Commission and the Australian Health Ethics Committee of the NHMRC. Several of the people who were involved in that inquiry are in the audience, I see, so I'll try not to misrepresent it too grievously. But the essence of the inquiry was, it had the long, silly legal terms of reference, but really what it was about were, in relation to human genetic information and the bodily samples from which that information can now be very readily and inexpensively derived, how can we best do three things? Protect privacy, protect against unfair discrimination. I've italicized that because the law, of course, allows us to make many distinctions among individuals that are lawful. Some people get better marks than others because they did a better job on it. Some people run faster than others, and we give them the medal and not the person who is slower. But in other areas where the discrimination is based on, say, race or gender or political beliefs or other factors, we say that's not fair. And so how does that play into this area? And then finally, how do we ensure the highest standards of ethics? And I think an important role of the Australian Health Ethics Committee in that process was to continue to remind us that the ethical part wasn't simply about scientific and medical research. When we got to the socio-legal bits, there were a lot of very thorny and very, very important ethical issues that needed to remain under the spotlight. And then we started from that narrow area. So the front page was about discrimination in relation to the acquisition of insurance, possibly smaller number in employment, a couple of rare cases in the provision of government services like retraining, job retraining programs. We brought together a lot of the leading people in this area, the scientists who were talked about as potential Nobel Prize winners in genetics, the leading bioethicists, human rights lawyers, a whole lot of other people, about 30 people in the room, including, I think, all of the people seated with me and a number in the audience. And I said to them, tell me what are going to be the big issues in this field now that we've had this breakthrough, these rapid developments in science and technology, but not just in the next year or two, because we're writing a report to government to lay down a legal and social policy platform that should last us at least a generation. So what's going to happen over the next 10, 20, 30 years? We wrote it all down and we handed out the chapters to the various researchers at the ALSC. And within 2 years, every single scenario that was speculated to happen by the leading experts over the next 30 years had already happened. There was already a reported case somewhere, usually in the US, but quite a few in Australia as well. If you look at the scope, so our report kept getting bigger and bigger. If you look going down the left-hand column, those are the things that are much more in the health and medical area. So how do we ethically oversee genetic, scientific, human genetic research? How do we provide enough clinical genetic services for the community? And most particularly the systemic healthcare issues. How do we get our health systems prepared for the day when, as the Canadian government said around that time, all medicine will be genetic medicine? How do we make sure people are trained? How do we make sure that GPs, who are the gatekeepers of the system, have enough knowledge about genetics to understand a matter when it comes to them initially for presentation? How do we get enough genetic counselors into the system? And I think we described formally genetic counselors as the hero of our inquiry, because they were the ones who actually explained to a lot of very panicked people what their particular situation was. So often we heard the story of person goes to doctor or gets or hears from another family member that they've got XYZ syndrome in their family. So of course the way we do things these days is you go and Google it, and then it scares the wits out of you, and you don't understand that you might have that 1 in 200 possibility of getting it, or you may have no chance, or you may just be a carrier, or you may have no chance for other reasons, or it may be something that you need to deal with immediately. So genetic counselors. How do we deal with population genetics, or population genomics, which is where the research is increasingly going? And so the accumulation of large biobanks, the UK Biobank has a target of collecting 500,000 individual samples. The Japanese biobank under construction, very similarly. A failed biobank effort, as you may be aware, in Iceland, where they did too much without telling anybody what they were doing. A very top-down approach without appropriate community consultation. It's now used as a model for how not to do those sorts of things. So we have the collection of tissue banks, familial cancer registries. Again, Bob mentioned a little bit of that in his introduction. Going down the right-hand side are some of the things that you might not have thought too much about in this area. Employment. Can employers require you to take a genetic test? Can they compel you to provide genetic information? And interestingly, around the time we were doing this, I got together many of the HR directors. I had a series of about 5 breakfasts, I think, with about 10 or 12 HR directors at each, so about 60 of the top 100. And I said to them, are you doing any genetic testing now? Do you require? Oh, no. Would you ever? You're thinking about it. No, we would never do that. And so how many of you do psychometric testing? Every hand in the room went up. How many of you do drug and alcohol testing? Most of the hands in the room went up. And I said, so you're telling me you're not going to do this when it becomes really cheap? Oh, well, maybe we do. So the tone changed very dramatically over the short period of time. Similarly, with many others we visited, they said, this stuff sounds really interesting, but we have no idea why you're talking to us. And then by the end, they could already see that there were some very important applications which they hadn't thought about at all. So employment is one. Insurance is another, probably the area that's been most ventilated. And again, in the risk-rated insurance areas, primarily life insurance, that is quintessentially what the insurer is doing, is looking at predispositions and probabilities and health and family, because they've been collecting family health information for over 100 years, much longer than doctors have actually been utilizing that information. And they've got actuaries who convert that kind of information into risk rating. A lot of the literature in the area, though, again, comes from the US, about which you have to be very careful because they don't have the mostly they're talking about health insurance in the US, and we don't have risk-rated health insurance in Australia with a comprehensive system and community-rated additional private health insurance. In the forensics area, it's not science fiction for police officers anymore. In fact, we wouldn't have evening primetime television. I think with that DNA testing, almost every program now seems to be people running around and collecting DNA and running it through the computer and getting cold hits or hot hits or doing whatever they're doing. So that's become a very, very important part of modern policing. It's a big issue around the world. It's an interesting issue in Australia where we have a couple of different models around Australia, one model being much more civil libertarian one, another being a much more law and order model. I don't even have to run through the states. I think I'll leave it to you and you will pick very accurately which states and jurisdictions have which of those two models. But we also have a lot of expertise, unfortunately born of things like the Bali bombing and so on. But our AFP is one of the leaders in the world in being able to do identification bodily remains from very small trace amounts. About a third of the people who were identified as having died in the World Trade Center terrorist disaster, a third of the 3,000 were identified purely by DNA testing, including at least 2 Australians. So it's quite extraordinary, even in that sort of inferno where the other means of identification are completely not possible, DNA testing is still possible, even in those circumstances. A big issue. Kinship and identity, not exactly what Ian was talking about, but lots of major issues in relation to indigenous people, of course. Starting with a whole range of these issues, parentage testing, paternity testing, to what extent should it be regulated? Do both parents and or the child have to consent to it, or is it something that one parent can sneak away and do the testing of without the child or the other parent knowing about? Immigration. You may have read that France now requires DNA tests for all people who are applying for immigration. Kind of transparently something to harass Muslim people with, but they brought it in. Most other jurisdictions have not done that. In Australia, we allow the use of DNA testing in certain circumstances. If someone comes and they're claiming migration status by reason of family reunion, and they have no papers, no way of linking up. They're allowed to present evidence of DNA parentage testing in order to make that familial link, but not compulsory. What about use of DNA to construct ethnicity or aboriginality? We had, when ATSIC still existed, an activist in Tasmania objected to 800 people on the roll of electors for an ATSIC election, saying, it's a small community, we all grew up together, I know all of you, you never identified as Aboriginal, and now suddenly you are. Now, many of those people came forward to the federal court and said, well, I can prove by use of DNA. So here's a document that says this woman is an indigenous woman, and I can show that that's my grandmother, so therefore I'm an indigenous person. Well, is that how we construct identity? The general rules talk about self-identification and acceptance by the community, a social construct. Can we use DNA? I think not personally, but can we use DNA to construct ethnic or racial identity? Terrible stories too in some places in the US and Canada where there are so-called blood rules about whether you're allowed to remain on a reservation or not. So kids who've grown up on a Native American reservation get to 18 and they're told, sorry, you've fallen below the percentage of indigeneity that's required to remain here, goodbye. So again, is that the kind of construct we want? And then a whole range of other rights and services, which first we thought was loopy, and then the cases started happening. So private school says, we'd love to take young Johnny, but we have a lot of these boys with ADHD bouncing around the walls, and we want a genetic test to see if he has a predisposition to ADHD. Or we'd love to have Gran in the nursing home, but we've got a big problem with early onset Alzheimer's, much more expensive. We want a genetic test for that. Is that the kind of community we want? And similarly in the sporting area, the Australian Institute of Sports, about as high-tech an operation as we get, and they use a lot of genetic testing and information. And I remember phoning up their chief medical officer, now the director, and said, and I wasn't trying to be like Columbo and get a sneaky answer. I'm just interested in the kind of rules and procedures and protocols you've got to manage that, especially since so many of the people at the AIS are young. And there was a long silence on the end of the phone. But to their credit, they didn't kind of, lie and obfuscate and pretend they were already working on it, and we've got something that's better than you can give us, and you don't really understand, and we're competing against the Chinese. It didn't do any of that. They just said, oh, dear. And they set up a committee. I think, Bob, you were on that as well, and I was, and a number of other people that mixed disciplines. And the AIS now has, by far, the world's best protocol on the ethical use of genetic testing and information in sport. The world, what's it called? The WADA, the World Anti-Doping Authority, thinks it's the best one in the world and wants to use it as the international one, but we cannot get the ministers. Successive ministers will not sign off on it. They're scared of the word genetics in there. I think there's no other explanation. But anyway, so there's all of those potential applications and more. The report that Bob mentioned, Essentially Yours, said it's a big, wide issue. One-size-fits-all solutions won't work. We need a very wide array of strategies that will include law and regulation, a lot more education, getting industries engaged in working out how it relates to them. I got the lovely compliment from Francis Collins, who is the head of the Human Genome Project, now the head of the National Institutes of Health in the US. He did that at the World Genetics Congress in Melbourne, I think a few years ago. I had no idea he knew about the report, but he pulled it out from under the lectern and waved it around. And I was furiously writing down the compliment, which I've used once or twice since in presentations. And then we gave our report to the government with 144 quite challenging, I think, recommendations. They took a while, 2 years to respond, but they responded very positively. And so that about 90%, I think, of the recommendations were accepted, and they've steadily been implemented. I'll talk about just a couple of the major ones. In the privacy area, the Commonwealth Privacy Act has now been amended so that genetic information is expressly covered. It's put in the category of sensitive personal information, so it gets the highest level of protection. Arguably, a lawyer could have made an argument that it would be covered by that before, but it wasn't in there, and it wasn't thought about when the Privacy Act was originally drafted in 1988. So it gets that good coverage now. The national statement that governs research has a chapter dedicated solely to privacy issues in relation to biobanking. We also recognize the shared familial nature of genetic information. So my genetic information, a DNA test in relation to whether I have certain markers, will obviously be of value to my kids, to my siblings, grandchildren, up and down the line. To what extent should there be sharing there? And the ALSE made some, I think, avant-garde recommendations there, which were accepted, amazingly, and we're now a little bit of a test case for the sharing of genetic information in certain circumstances. We also, and I've spent a lifetime in law reform recommending against the use of criminal law in most things, but in this area, we were so alarmed at the possibility, at the ease of collecting someone else's DNA and sending it for analysis, and of the consequences that could flow from that, that we recommended the creation of a new criminal offense for illicit DNA testing, testing someone else's DNA without their knowledge and consent, or without other lawful authority, so a police officer who's doing it under their own legislation. Okay, and then finally, anti-discrimination law. We recommended, and this is to the Howard government, which wasn't exactly championing workers' rights at that very moment. We said we cannot have the creation of an underclass in Australia in which people are fit and ready to work, but an employer says, well, now we got 10,000 applicants and you've got this marker that gives you a 1 in a zillion predisposition, so what the hell, we're not going to hire you. It's one way of weeding out people. And our workers' comp premium's already high enough, and we have problems with sick leave, so anything we can find in that way. And so we recommended, first of all, that the Disability Discrimination Act be amended so it expressly covers real or perceived genetic status, and that the bolded part there, insurers cannot request or require genetic information from an employee or an applicant for a job, except where that information is required for purposes that do not involve unlawful discrimination. So there may be circumstances in which there's a certain requirement of the job, not that you be a woman working in a particular area, for example, or that you not have a certain it probably would make sense for certain pilots not to have markers that show that they have Marfan's disease, which could lead to an exploding aorta and an instant death, for example. So there are some very, very few cases that you could find where that would come up. But in those rare cases, they could make that argument. And ultimately, we said, the technology is allowing us to do enormous things, but that doesn't mean it should be allowed to just go on without regulation in the public interest. And so we have to decide whether we're going to harness that science for human health and to extend human potential, or whether we want to have that kind of dark, bleak, geneticized future that we've seen in the excellent film Gattaca, in which genetics are used to stifle human potential rather than to extend it. So I'll leave you there. Thank you very much.
Thank you, David. Right, we have 20 minutes where it's your chance. And I'm sure there are questions, comments in the audience. Got a microphone down here? First question or comment from the front. Do mention who you are again.
Sounds great, the protections against discrimination with regard to employment. But this federal government, the previous one and the one before that, for federal government positions require applicants, mere applicants, not people who have been shortlisted for jobs, to provide and complete a 5-page medical condition statement, which I've always thought could be discriminatory. So they might have 2,000 applicants come in. Is the person with, an interesting condition going to feel that they didn't get the job because of what they completed on page 5 of that statement? Secondly, the whole issue of gene patents. I have a big problem with that. People making money out of human genes, or any other genes for that matter, but and obviously not to the benefit of anyone carrying a potential genetic mutation that's picked up in that process. And thirdly, the story of the poor African-American woman, Henrietta Lacks, who to this day, her body tissues have made billions of dollars for organizations around the world, while her descendants in the US can't even afford medical insurance today.
Thank you. Can we actually focus on the second of those points, the one on patenting, because I think that's the one of general interest that we haven't discussed. And I'll just offer a comment. When this was brought up this morning in the first session, everyone said, oh, patenting, it's all right, you know, don't really have a problem with it. I actually have a problem with it for this reason. I know that there are companies out there that hold patents on human genes that are actually using those patents deliberately in order to stop public laboratories carrying out gene testing on those genes, in particular on the breast cancer gene. And if a public laboratory is not able to carry out a test, then it seems to me that it's very, very counterproductive to human health. I'm not saying that one should never accept the principle that people who develop a product, people who develop a drug, should actually get a fair reward for what they develop. Because I must say that if we take that policy, we would not have a pharmaceutical industry. And the pharmaceutical industry worldwide, even though in many ways they are the bad guys, I mean, they do make enormous profits from these pharmaceuticals. On the other hand, they're doing a job that very few, there are lots of academics sitting here, hardly anyone in the University of Melbourne or any other university actually wants to do drug development. It is boring as compared to real research. And so people don't do it, and pharmaceutical companies do it. So we have a problem. You did some work on patenting, David. Why don't you say?
Well, it was the unsuccess story compared with genetic information.
This was the other volume.
Yeah. I mean, the report, I think, is very high quality, and in the usual way, it's been very influential all around the world, except in Australia. So we did another, when we were doing the Essentially Yours inquiry, and we did massive amounts of community consultation. In fact, the very first of those was in Australia. There were 17 big public forums. There were 300 meetings with community groups and experts. And quite a few people said, you know, one of the big issues here is gene patenting, the intellectual property dimensions of this. We couldn't really do that within the bounds of the other project, but I wrote to the Attorney General at the time and said, can we next do that? And he approved that project. So we did something on intellectual property aspects of genetics as relates to human health. So we didn't look at planters' rights or any of those things. We made 50 recommendations for reform. That report came out in 2004. And every 6 months since then, I've heard the government is about to release its response to your report. So I've got to go back and read what I wrote so I have some idea that I could remember. And then something happens, an election's called, the health minister changes, there's something in the courts. So we've not had that dealt with. And I think it's tragic because I think that the Patents Act obviously was not done with genetics in mind. However, it's a robust system that goes back many hundreds of years. It's dealt with successive waves of scientific innovation and other kinds of innovation. So it's dealt with purification of chemicals and new kinds of engines and new kinds of power. And in this area, what always happens is the patent examiners get overwhelmed by the beginning of the wave. So they haven't seen this stuff before. It's new, it's different, it's exotic. And they tend to give overly broad patents in the initial period. Then they become expert themselves and they steadily chop it back. So it's a much better system. So we're still dealing with the fallout from that in the genetics area, in which lots of pure gene sequence patents were given out. They should not have been. They don't comply with what the Patents Act says, which is that, sorry?
But they're still there.
Yeah, yeah. So some of them have been challenged, and then those that have been challenged, many of them have failed. Others just, it's expensive to challenge it, so it doesn't happen. They are temporal. The grant is only for a period of time, so others are starting to roll out. By and large, what we found is that overwhelmingly, there's pretty free licensing of this stuff because people want it used and they want royalties and so on. But there is some cynical use of it to suppress other people's rights, with the lawyers' letters that are sent around to try to stop other people from using it. So we made a whole lot of recommendations that allow much more strategic operation by government, saying you have to have people in government who know it's a good patent or not. They should be advising the state and territory and Commonwealth health departments that you should be using the same strategy we use for pharmaceuticals, which is use the buying power of government, and that you should step in when necessary. When there was the scare, just after 9/11, there was the anthrax scare. The US government said to the company that has the patent on the antidote, this is the free market US government that hates our pharmaceutical system. They said to that company, I forget if it's Pfizer or one of the big ones, but we'll have 1 million of doses of that, please. Get it ready, because we'll need it. And this is how much we're paying you. And it was almost not like $1 a dose or $10 a dose. So governments can do that. There is actually the power within the Act. There's power under international treaties where there are health emergencies or other things, but governments just don't do it. So we were saying, there are some amendments that are necessary, but also just do it. Just get active. Just be responsible.
Yeah. Thank you. Bob Phelps has a point on this, as I thought you might.
Thank you, Bob Phelps, Genethics. Would the panellists then support the private members bill by Nick Xenophon and Rachel Seward, which is currently before the federal parliament and is about to go down in flames because it doesn't have enough support from people like you? It's being put up against a government initiative which is called Raising the Bar, which doesn't do what you propose. I think Professor Weiss-Brought's quite right. Will the academic community and lawyers get behind the private members bill and make sure that this change is made? The American government has just changed its official policy on not allowing the patenting of discoveries. It's appropriate, and it would fix up Bob Williamson's problem of legitimate research being squashed by corporations continuing to patent discoveries and not allow particularly startups to enter the field of research and development in a lot of areas.
The Australian
Could we get that commitment from you?
The Australian Academy of Science, which I'm the Secretary for Science Policy of, has stated that the problem with that bill is that the way in which it's written means that it's incredibly broad. If that bill focused on DNA and gene sequences, I personally would support it. I don't think DNA sequences need.
I agree completely.
Yeah. Vanessa.
Okay, I'm going to change the topic. I want to ask the panel, how are you going to prevent what has happened and continues to happen in Southern Africa, for example, with indigenous communities, where publications are still published only a few weeks ago, with not a single university or representation from the country where the paper is about. How is Australia going to address this? Because one can't avoid it from happening. The globe has become a very small place. So I just thought along the ethical lines, how are you going to address this?
It's one for you, Ian.
Ian, do you want to?
Am I on?
You're right. You're
yeah. I think that's a really very challenging question. I don't have an immediate answer to you because I think that a lot of our regulatory frameworks around research ethics are really nationally based. So we're not very well set up to look at the increasing challenge of transnational research. But there is a global community of people who are thinking in that space. In Australia, we would find that sort of practice highly questionable for a whole range of reasons. It reflects a sort of a particular ethical, a particular style of research, what we would call in the old days helicopter research, where people would kind of commando style run in, take some samples, then run off and never to be heard of again. We would be promoting an approach to research that has a developmental framework where there is evidence of good engagement, and that good engagement is both recognised in the process of how the research project is brokered, but also too in how the research findings are represented and those research communities are engaged in the process in all stages of the research process. We still have some way to move in that in Australia. We need to move beyond just putting Aboriginal researchers at the end of papers just for the sake of it, actually thinking about what is genuine engagement in the research process, where's people's intellectual input. But I think it's a very challenging question, which is applicable across the whole field of health research, but particularly in this field that we're talking about at the moment, genetics research.
You know, Vanessa, I actually think the answer to that question, in some ways, the roots of the answer to that question were in your talk this morning. The fact that Desmond Tutu and the Hosan leadership were willing to participate in research over which they were respected and over which they had a measure of control, in turn gives them the right to protest when things happen in other countries that don't involve them. A complete rejection, as you said, which some of the elders in the Hosan community would not have given them that right. So empowerment is a very complex business. The empowerment here is to some extent represented by the participation in the kind of research that they want to see happen, because that in turn, I think, empowers people to protest when research of the wrong kind is carried out. Do you agree?
I would say, and now that I'm based in the US, I get asked this question a lot by colleagues, not within my institute, but within other institutes. They approach me and they will say, and I will not mention institute names or the institutes themselves, but they'll approach me and say, we have this sample, we have this, we have that. What do I think? Should they ethically work on that sample? You talk to them for a long time and you find that ethically under their IRBs, they're not doing anything wrong. When they ask me, would I personally work on the sample, I say no, because I lived in Australia. I have an Australian passport. I would not do that because I wouldn't know the answer from the actual indigenous group. But it may well happen. This is my concern, that how do we move it faster so that it happens together instead of, I can't prevent the work that we do. I haven't, although we have an approach and we have community involvement in our research, I can't prohibit what's happening on the field by other groups. And obviously that does impact what we're doing because the communities will eventually shut down and say, no more, it's abuse.
I think that not tackling these issues from an ethical point of view now does the longer term research project a great disservice. I still remember many of my friends and colleagues, having got to university, Aboriginal friends and colleagues, reading about that researcher that was in their community in the university library and suddenly realising that that person was an anthropologist, that person who was staying with their grandmother. At some point, people from highly disadvantaged and underserved populations will be reading the outcomes of this work. It will not, that broader relationship, that broader collaboration that's based on an ethical framework of trust will be irreparably damaged.
But it's also why the work you're doing with Emma to try to bring the Aboriginal communities into the research agenda is so critical. Because if the research agenda is just rejected, then we'll finish up with much more serious problems down the course of things, I think. Question. We have time for a couple more, because we've got to finish at about 5.
Hi, my name's Anne Blair, and this is directed to Ian. It's a sort of a couple-pronged question. Do you find there's a lot of resistance in the Aboriginal community because of the history of collection of data and bones, etc.? And do they feel that this research will be used against them? And also, what are their feelings, and could this research also be used for identifying families of stolen generation and adoptees in the community?
There's a lot of issues in that. I think that very much a lot of the contemporary relationship is based on a historical relationship and on real histories of exploitation, but also to a lack of kind of trust that builds up through that historical process. There have been some. You've got to remember that my Aboriginal world is a very tight-knit world. We have very strong relationships, very strong kinship ties. So there are communities here in Victoria where people are still talking about that young PhD researcher who came into my town and took all those samples and did all those tests and didn't tell us what it was all about, and that was 30 years ago. So that those kind of the kind of impact of those areas of judgment manifest in very, very significant ways in terms of that building that relationship. I think part of that the big challenge is to build that trust, but it's also to find ways to bring Indigenous Australians into the higher education system and into that field of knowledge, so that you can actually transact some of those relationships in very different ways. It will never be the case that all research is done, or even in the future, by Aboriginal Australians, but having Aboriginal people in the kind of knowledge system that is the university does an awful lot to broker better relationships. I think with the issues of stolen generations are very complex issues. I think sometimes that's really more in the realms of historical, genealogical research. It's more about connecting people in the contemporary world. There may be some cases where some forms of investigation are warranted, but often, by and large, that's done through oral history and other forms of family history, which is, I think, a very valuable process for connecting people who have become very traumatised.
Last question. Comment, question, whatever.
Hi. Bob, Ian and David have all spoken to some extent about the issue of genetic literacy, and Bob mentioned this morning that one of the good things about the kind of test we were hearing about this morning is the extent to which they empower people to make decisions about their health. But in companies like 23andMe that provide genetic tests over the internet, they're not really empowering people because the information is provided without context and without the information needed to make sense of that and to actually use it to make meaningful health decisions. So I'm just wondering what strategies you think are appropriate and what policies are appropriate to help people deal with this sort of influx of information that they can now gain access to be truly empowered to make decisions about their genetic health and to improve the health system to provide the support necessary to achieve that.
I don't know if that's to me, but I'll take it. The first thing to say about 23andMe, Decode, et cetera, is these companies have been in existence and offering this service for a grand total of 2 years, maybe 3 years. It's a bit unreasonable to begin to say, oh, well, they haven't got a proper protocol and so on. It's very, very early days. I actually did a little fun I was going to say a job, but they didn't pay me anything. I actually helped out Channel 9 interpret 23andMe data that they got on Lane Beachley, on Scott Cam, and on one of their presenters. And the interesting thing about it was the data are good. The data are absolutely perfect. There's nothing wrong with the data. The interpretation ranges from being total crap to relative crap. It's actually not very good at all. And having said that, when you actually went through the data are fine. I think part of the problem is that the companies are really learning how to deal with things as they go. They launched far too early, far too quickly. They're terrified of the anti-abortion movement in the United States. So for instance, there's data there on whether you're a carrier of the cystic fibrosis gene, and they won't tell you because you might use it to do a prenatal diagnosis and terminate a pregnancy, things like they're totally at 6s and 7s on the Alzheimer ApoE4 analysis, although the data, once again, are there. So I think give it a year or two. I mean, the one other point I'd make about it, at the moment it says you're at a higher risk of having a heart attack by a relative risk of 1.1. Well, since your risk of having a heart attack is roughly 35%, that means that risk has gone up to 38%. That's not the sort of thing you, in your wearing your medical hat, would really even think about. You know, it's not a relevant piece of information. So they're giving the wrong stuff out. Give it a year or two, because I think my guess is this is going to change. I think when it changes, it's going to be very, very interesting if people get the relevant information. I think, I mean, at the moment, it's easy to knock the companies, but when they're offering really interesting and relevant information for $99, maybe there'll be a queue outside waiting. Well, I don't know about that. You know, I think we diss people a bit. I mean, I'm not a medic either, I should say. I'm a scientist. But I did do a lot of counseling. I did do a lot of genetic counseling over the years, particularly in relation to cystic fibrosis. I found that a hell of a lot of people had a very clear idea about the degree of handicap they would or would not accept in their children. Well, Ian, you're a medic. I mean, ordinary people have very clear ideas, particularly when it comes to reproduction, on what they're willing to accept and not willing to accept. I don't accept this idea that people, just because they don't have a degree in genetics, they won't be able to understand family history and genetics. Ian?
Look, I feel like I've been drawn into this one. I was a clinician. I've just been outed, a medical doctor for some years. My reservation around this, and I'll qualify this reservation, is that there is an incredibly complex psychological process that happens with the receipt of information about health risk. Now, I don't take the view necessarily that people, the general community, are unable to unpack that, to understand that, and so on. But my anxiety personally around that is around potential consequences of that emotional response. Now, having said that, this is the qualification, the horse has bolted. You know, there is a very vast new world out there that people are using the web and the global resources that come with for sourcing out health information. So it seems to me, even though I'm probably a very old-fashioned clinician in some ways, I think that we need to deal with this reality and to think through the sorts. I think the problems that you're putting out there are real problems, and we need to engage with them. How that might lead back to a human encounter is probably one of the real challenges.
Last words, David Llewellyn.
I have lots of problems with the direct-to-consumer marketing of genetic services, and particularly by many of those companies that you mentioned. There's no federal privacy act in the US, and you'll find that most of these labs are located in low regulation states. In fact, many of them have moved in recent times because they've gone from higher regulation states like New York and California to low regulation states like Utah, where there's virtually no control. So if you do a buccal swab, stick it in a plastic bag and send your stuff overseas, you have no idea the purposes for which your genetic information may be used, what privacy protections you get, and so on. if you are applying for insurance here, you will be asked, have you done a genetic test and what were the results? And if you've done that for reasons that are mere curiosity and they weren't really relevant to health information, then I don't think that's a sensible thing to do unless you've really thought through all of the consequences. If you read the websites carefully, you have to drill down many levels knowing what you're looking for on 23andMe for it to say, this is not medically valid information. This is a research project. Now, if you go up on the front page, that's not what it says at all. It's indicating that you're getting valuable information that empowers you to make health decisions. That's not what they think. So you go down, or if you read interviews with the two people who founded it, they say, no, this is a research project, and it's a research project in which they openly sell their data. So you can go to any research project at Melbourne University, and they'll collect your stuff for free. They're not going to charge you $500 to $1,000. They will protect it under Australian law, which is pretty good on privacy, and so on and so on. You're protected under discrimination law here. None of those things apply when you do it elsewhere. Some, but not all of those DTC companies offer genetic counseling. Some of it is okay, apparently by phone. None of them, by definition, I guess, have you sit down face-to-face with a genetic counselor who works out your pedigree and explains all this stuff. So I'm very worried about the worried well, the people who get these results that say, oh, you're a bit up on these things, but there's no real problem. I'm also worried about the people who were told they don't have a problem. So you don't have a problem with BRCA mutations, the common breast cancer mutations. I don't want those people to stop routine checks, mammography, all those, and that does happen too. Oh, I got nothing to worry about in this area. I don't have the marker for colorectal cancer, so I don't need to go have my checks. I think that's a terrible thing as well. So I think there's a lot of problems with the way that's being offered. I mean, there may be a time down the track when they'll solve those things, but at the moment it's being, we know that it costs about $2,500 to do the fully sequence, the BRCA mutation now, and they're saying we're going to survey 99 common disease mutations for $99. Well, it's like any other, and we'll give you steak knives kind of offer. I think you got to be very suspicious of what's going on. And finally, Craig Venter, who was the head of the private consortium that led to the Human Genome Project, the private counterpart of Francis Collins, he sent his DNA to 9 different major DTC companies, 23andMe and some of the others, and got a whole bunch of very different results back for the same things. Now, when they tracked back through that, they found that the companies themselves had high quality assurance by and large, they had good equipment, the results were proper. So what was the explanation? They were using different markers. So for one particular disease, company X used a particular marker, which you did or didn't have. For the same supposed genetic condition, another company used a different marker, which you did or didn't have. Now, what possible value could that be, in terms of empowering people to make very important health decisions?
Early days, David. Loanne, very final, nothing? Yes?
I have one comment. Embryo research used to be controversial.
Right. Okay, a lot of you are coming back tomorrow, which will be great. A lot of you have stayed all day today, which has been great. But for the moment, thank you for coming, and join me in thanking the speakers.